Hi everyone. I will try not to keep you very long, even if legal aspects is an endless subject. And because we are before lunch, we should finish just in time. My name is Christian Driga. I'm a lawyer and also executive director of an NGO doing research in the field of cybercrime and um, electronic evidence and cybersecurity. And uh, this presentation is mostly about usual aspects we meet on the ethical hacking activities. Um, and I will actually start with some real life questions for you. Um, do you think that poor protection of a computer system or data deserves to be exposed regardless the consequences? Anyone? Um, sorry? Disclosure, yes, or publicly exposed, presented in events. Um, if what if a company does not respond to your call regarding the vulnerability you have discovered? Uh, do you think the vulnerabilities should be uh, published anyway? Yes. Okay. Uh, and the last one, when you get hacked, do you feel the need to strike back? How many of you have been tempted for about this? One. Okay. Now we will go to preparedness questions. Preparedness in meeting the law, the legal consequences. Has anyone read actually the criminal law provisions on cybercrime from our criminal law code? No? One, two? Okay, so. But, and how long is the chapter on legal aspects in ethical hacking manuals? Actually, I haven't managed to finish reading such a manual, so I'm asking you. Did you see legal aspects in? Okay, I will not ask the third one. In the ethical hacking activities, do you feel that the legal system offers enough protection for you as security researchers? No, it's a general answer. Okay, let's see where this comes from. You see, we have technology and we have law. Technology in year 2000, when the basic law, the Cybercrime Convention, was issued, uh, was mostly desktops, laptops, bulky systems, and of course the networks and the internet. Technology has evolved tremendously in 16 years. We have Internet of Things causing a lot of problems right now. We have cloud computing, and information systems actually are everywhere in every aspect of our lives, and they are vital. And vulnerabilities are actively exploited everywhere and hunted. Um, and they have actually good prices from on the black market. And also, in relation with the IoT especially, we have irresponsible companies not willing to offer support or not responding even to any notifications regarding security vulnerabilities. Also, they are abusive through the end user license agreements and usage terms, in the sense that they assume no responsibility whatsoever for the losses you may suffer or the problems you may have if you use the device you buy from them and which actually contains an information system. During all this time, the basic law defining cybercrime offenses and widely and uniformly adopted on many countries right now has not evolved. If nobody in year 2000 could envision that an information system will become this small, or it will be inside any device at home, and a TV and in the fridge and so on, this creates a problem also from the law enforcement perspective. If a crime is committed through using, for instance, a fridge, do they take it for forensics? How do they manage this? So many IoT devices infected right now and participating in crimes against other computer systems. How can law enforcement intervene? In the same time, the convention defining all the main offenses defines illegal access to information systems, which is crucial in finding vulnerabilities today, when it's almost impossible to find every vulnerability if you don't get help from the others. A company has simply no way of finding by itself all the problems that it created through bugs in programming or other bad configurations. So one reality that changed is that we need a way to be legal to access systems in order to test them. The judicial system, on the other side, I mean the courts, the prosecutors, are still learning the basics of IT technology. So if you bring a case to a court right now, at least in Romania, where my experience comes from, in various parts of the country, you'll find very different or even very little understanding of the notions involved to determine if a technical fact has which legal consequences. We know that from the difference between a 0 and 1 in an information system, someone could be convicted or not, but the courts have great difficulty in understanding this and pinpoint the exact information relevant to make a decision. So I already mentioned this, the growing need to redefine some of the offenses, of the criminal offenses in cybercrime related, at least the illegal access, in order to enable somehow ethical hacking. I'm not saying eliminating the incrimination, but offering some legal protection in the interest of security research and identifying and contributing to the greater good through such technological testing of the systems. This brings basically us to the last of the preparedness questions, feeling secure with the law. And right now, the law and the judicial system brings quite a lot of insecurity for the security researcher. When we do ethical hacking, we have too many laws to take into account. The criminal law, the criminal procedural law, which may provide us some ways of getting out of an investigation, but we have to know that. Copyright laws, I remember a case, if I'm, correct me if I'm wrong, with Sony PlayStation and the police getting all the equipment of the guy who rooted the device, because copyright law stated that they are still the owners of the device, even if he bought it. This is another very interesting aspect. The society has still no idea that when you buy this device, only the electronic equipment is yours, usually. And but the software inside might still be the property of the manufacturer, which is very important to take into account when trying to hack the device. Data protection laws. This is another pain for the for the security researcher, because, for instance, in Romania, the law states that testing an equipment or a software for security problems should not be done on live systems having actual personal data on them. Forbidding this basically forbids us to test any live website which has, for instance, a client list and their emails. It is an aspect to take into account. In the same time, entities processing that personal data have obligations to notify if they have data breaches. Right now, under the old law, it's still an obligation only for the communication systems providers, but soon, under the new European regulations, it will be mandatory for every entity processing personal data to notify. Well, in this case, how do you, for instance, hire an ethical hacker, hire him to test your systems? Basically, with the other provision that no personal data should be on the system, you have to set up separate system, a clone, just to make the test. Otherwise, the entity risks, and under the new regulations, the fines are very, very high for data breaches and not notifying, for instance. Well, another aspect of the law, of the legal system, which we need to have legal security, is the predictability. Similar decisions in similar cases, which right now in our legal system, at least, it does not happen. Previous judgments do not count if they are from lower courts, only from the High Court of Justice. And also in the judicial system, I have met in my experience a lot of misunderstandings. For instance, we have the provision in the criminal law code punishing the usage and the procuring and distributing software programs, passwords, and other 0 days and in general information that could help or could be used in committing a crime, in a cybercrime offense. So, if, and this is an aspect relevant for you using and having all those tools and testing all those, for instance, malware and stuff and all that stuff. But I have met in court the situation where the prosecution, in a case where someone used for child pornography and file sharing program, uh, they deemed it like being illegal. And the court did not understand that that software was in fact legal. So that client had not only the child pornography offense committed, but it was added to it the illegal usage of software. And also, one other problem is the technical knowledge needed in the IT cases. And relying only on technical experts is not enough. The courts need training in order to understand the IT notions. All this gives a pretty worrying picture of how protected we are when we act in the field of ethical hacking. So, what can be done? Shall we go home? If a relative of mine, he was always saying to me that, after consulting me, that if you want to not to do something, ask a lawyer. He will find tons of motives and dangers to give up any idea you might have to do something. But still, what can we do? First is the paperwork and keeping evidence. If you do ethical hacking, penetration testing, this is very, very important. Second, if you are an employee, there are some rules you have to follow so that you do not receive an order from the boss to do something that actually might also in the end charge you for or file a complaint against you. It is advisable, if the legal system cannot, and it's the harder to adapt, cannot get to the same speed with the advance of technology, it is advisable that we at least try to see what's in those provisions about cybercrime, how they are usually interpreted. So a little bit of hacking of the legal language and the logic behind that does not hurt. Actually, it may help very, very much. And then we as a community, we can contribute and help the judicial system evolve. But for this, we have to get together to reach out, because it's security research is a profession. It's something that needs protected by the law. It does good for the society. So this requires some establishing some links and some common views on how the legislative could help, how the authorities could help. And I will come to this one with the public recognition in a moment. So, paperwork and evidence, just in short, because time's running out. Bulletproof your contracts. There are so many aspects, and I've seen penetration testing contracts on only half a page that cannot protect you. If you put there that the client takes full responsibility for any consequences, it's not enough, because you don't know what the client understands from that. So you have to define the terms. in the contracts so that he cannot say, oh, I didn't know about that. You have also to assess every method that you will use, all the tools that you will use, and how will they be used. I know this makes a lot of paperwork, but he cannot claim, and authorities cannot go against you if you had agreement from the client to use those tools. And the first one, which I passed, assess all the systems that will be accessed. Find the real owner of the systems. You do not test a server if the server itself, if it's on shared hosting, the website is on a shared hosting, because you affect actually the provider of the hosting, not the client who has only an account there. You know, you can test only the scripts on in that account if you have agreement for testing for cross-site scripting or other things, but you do not go with other methods that could affect the server. It's so depending on what is the purpose of the penetration testing, you have to assess all the systems that could be affected and find the real owner. Because even if your client says, well, this is my server, and he doesn't know very much, and in the end they were just on a shared hosting account, he cannot. You are responsible, not your client for that. Okay, at the actual testing, the safest is to stop once you have proven the first vulnerability, that there is an entrance. Do not go beyond that unless it's written in the contract. Because anything else you might find, including personal data of his employees, I don't know, is give the right to third parties to sue you and also sue him. But anyway, so, and of course, take evidence of and document every step taken in any way you can. This is most important, because if you acted in good faith with the agreement of the client, in the end, you have to prove that. The authorities will not believe you only because you say that. So document everything you do. And if you disclose, keep in mind that publishing still has risks from third parties affected. You remember, it was quite recent, the Volkswagen case, when when it was discovered the vulnerability in the chips from the car keys. The maker of the chips was notified. He did nothing. They wanted to disclose it, given an amount of time, and Volkswagen intervened and stopped it, because it was tried to stop it because it was affecting all his clients until that moment, hundreds of thousands of cars. Okay, I already said that. Try to read the provisions in the law. Try to find out how they are interpreted by the court. Do not hesitate to ask a lawyer for that, because, for instance, access means entering the whole or a part of a computer system or network, no matter the method. Unlawful means that it's without authorization, which in turn translates as get authorization from the right person to do that step. Courts and the prosecution also takes into account the real intentions and the motive, so you need those proofs. And also the immediate result of the offense, what damage has been done. try to minimize the damage. And to link to this, the criminal procedural code has gives the possibility to the prosecutor, if you prove all that from the previous slide, that he can drop the charges if if he finds there is no public interest for prosecuting you further, given the small importance of the actual crime committed. And this one actually helped a lot of one of my clients. They take into account the person of the suspect or defendant, their conduct previous to the offense. This means, and my client happened to be someone who had previous presentations even here. He was publicly known. The cybercrime unit from our police knew him. They were actually, in the sense that they knew his work. They were actually fans of him, which made them believe him when he claimed he did not try to commit any crime. And of course, with the help of the lawyer, he also proved the rest of the actually what he did. So get public recognition next year's Be on the Stage. It's very, very important if you continue in this field to get some to get to be known. Also, if you are participating in bug bounties, get and keep records, letters of thanks from the companies you have helped, anything, because it's very important to that the prosecutor sees who you are, that you are a white hacker, that you are trying to do good, and this proves your previous conduct in the field. These are other aspects, and I will close with this. If you are an employee, do only what fits the job description. If somebody asks you to do something through a computer, which may be some offense, anything, try to confirm, to have the written agreement. There was a case of a journalist who also built up the initial site for his newspaper, and but he didn't have in the job description the system administration duties. And when somewhere later he approved a comment that did not wasn't liked by the owner of the newspaper, he accused him of illegal access, and he had to prove somehow to the prosecutors that he had the right to actually modify those pages. In the end, he got only a fine, but he was considered guilty because he did not have, everything was verbal inside all the orders he had received to actually maintain the site. And of course, the other employees did not want to get into his defense, fearing for their jobs. So they did not testify that he was actually the guy maintaining the website daily. This is quite logical, I think. If you get hacked, do not hack back. Preserve the evidence, document the case, and file the charges. And the last one is what I told you about getting together and demanding what's needed for you to do your ethical hacking profession. Demand amending the laws. Help the judicial systems reaching common definitions in the laws. Try to reach out and help in this one because it's interpreting the terms and understanding them is very different. An IT guy from a lawyer or a judge. And this one actually is an initiative going on right now. Coordinated vulnerability disclosure policies. One organization is trying to get things moving at international level in this field. They issued a manifesto, the declaration that which can be, it's open for signing by the companies. Ask your companies, ask your clients to rally to that. It's a public declaration that they will adopt some mechanism trying not to hit you back if you reach to them to announce a vulnerability, but rather they will create some mechanism to see if the bug confirms and coordinate eventually with you if you want to publish about it after they have solved it. So this is it. Well, it's 1:05.
Hi. My name is Maksym. I'm working in the information security field. What attracted me the most, besides the first question slide, the last one, maybe the one before that, you mentioned that we should help the system evolve. I speak somehow knowledgeable of the fact that the lawyers and IT guys are like have separate views about the technical part. But as a first step in this direction, what could be? Like make a petition, because you know this cybercrime law that is pending approval for like 4 years.
Okay.
It's very debated. What can we do to help it reach common definitions?
Well, like for instance, this initiative trying to get some legal provisions for vulnerability disclosure. The same you can through civil society organizing yourselves, can try to reach out to the government and to the relevant authorities and publish what should be actually from the technical point of view the reality that should be taken into account. It's not an easy process, but what I see, what I've seen in the last 12 years is that the two systems, IT and law, are going apart. Nobody trying to reach out and at least have a common understanding. If the law and the judicial system, maybe it's harder for them to make the first steps, perhaps you, which are much younger and very much mobile than them, can reach out and try to make them see the real needs that the society has evolved, and the law should reflect the evolution of the society.
Thank you very much. One last question. I have no law formation, but what is the thing I can do? Like join an ONG,
Yes.
NGO, maybe make one professional society.
That.
Okay, thank you.
Please. There was also a question there.
Oh, okay. Hi. So my question is, I've seen you're within the Cybercrime Research Center in Romania. Have you heard of Romanian Center of Excellence, CyberX?
Yes.
Yes, okay. Well, besides that, we did some workshops in there for judges and prosecutors, and we are trying our best to get that level of knowledge in IT, basically, to get there to make them understand the zeros and ones. Okay. Have you done any workshops, or maybe we can partnership somehow?
I,
Because it's very important to do such activities and invite all of them
yes,
in this field.
indeed. And for several years, I was trainer at the conference that took place in Târgu Jiu on the continuous formation of judges. And but from what I know, from the at least for the magistrates, that continuous formation is optional, like the theme that you can choose, from what I understood, where to go. So and also at the National Institute of Magistracy, there is, from what I know, no training, initial formation on this. In my view, of course, I am, and I was always open to cooperate, because trying to teach in court, in the actual case, the whole notions needed, it's hard to do. So, yeah, of course, anytime.
So, how much is European law or European legislation or the European lawmaking process influencing the situation in Romania? And would it not be, or how interesting would it be to influence European legislation instead of Romanian?
Okay, all the legislation in Romania should be within the framework of the European law. New regulations are implemented once they come out from the European law, but getting the reverse process, well, this is something that authorities should gather from the realities of our country and what's needed, and eventually propose the changes. I have no experience on these mechanisms, so I cannot elaborate on that. But it's part political will, part having the right information, which means getting all together. And
Okay, cool. Thanks.
please.
Hi, I have two questions. One, do you see in the future in Romania an institution that will demand from IT companies to continuously test the security of their software product that they develop?
Are you familiar with the NIS directive?
No.
It's a directive right now regarding certain security requirements from essential service providers and public service providers. I don't know exactly the term. Anyway, online services, digital services. This is something coming from the EU, which actually enforces some of these some continuous testing and adapting strategies and so on. The rest of the market, until now, only that if we will have the cybersecurity law adopted, which until now it wasn't a success. It might be possible, but I don't see it like forcing, but rather through other mechanisms, like having standards for being able to, for instance, participate in public procurement and to make contracts with the state. For instance, this would be a way that um,
So currently, the law doesn't demand from a company that develops products to make them secured, but in case a breach happened and the clients have some issues, I mean, with that, the company can be sued and the law can be used against it.
I forgot about the data protection laws, which require you to protect the law, to take technical measures, physical measures, etc. But in the end, so you have only on that basis, if you process personal data, you already have some obligations to do it, and there are fines for not doing it. If you lose the data, if if the data is compromised, you can be sued not by the state as a company, but by your partners, your clients. You can lose market share, and so on. Depends on the magnitude of the problem. Okay, any other questions or?
Okay, from my part, there is any legal authority where you can pre-register a penetration contract? Okay,
Pre-register?
a penetration contract, for example. In the case of firm and people, you have something for the firm, but if you want to make a penetration contract from another individual, so you just write a paper, but if you don't go to
If let me try to rephrase. If you, for instance, uh, get someone from this room able to do penetration testing, and you as a company make a contract with him.
as a company, as individual, so maybe we are friends and you are not a company but you have a personal website and you want a security audit on that website.
Okay.
So
Contract between two persons.
exactly, but without need to go to
You don't. It's a civil contract. You don't need to register it somewhere. You need to have the to have it actually, to have the real signature. I
so
don't
this
know
is
if you
enough.
can be a register of all the penetration contracts made. You know that those contracts would have to be in copy there. So, but they contain private information like what systems should be accessed, what are the means, and so on. I don't think it can be done in a way in which you can register it. It's an understanding between two persons. The law between them, a contract. So you're not hungry?
Okay, let's say things go bad and now we have problems with the law. The client probably sues us. So it's no longer a talk with the client. Now it's a talk with the law enforcement. And those guys shows up at your door or they call you in their office. So you give them explanations. Now, I know the first thing you should get your own lawyer, but I mean, can you use anything to protect yourself, like encrypt your data, like not disclosing your passwords,
Okay, and
any stuff to them? I mean, can they enforce you to give?
no. They cannot, but and you also have as a defendant the right to silence until you get to the trial. But
Okay.
this is guaranteed also in the codes. So and from what I know right now, cannot be forced to unencrypt. But this refusal could be taken into consideration. Well, he refused to cooperate.
Yes. Can they prosecute you for that?
If they find no evidence that you committed, it's only the complaint and there is no evidence. Well, I don't see how it could hold in court, but if there is some credible evidence and you did not want to give the rest, then this will hold in court, and it will count also that you have refused to cooperate. Because on the criteria to establish the punishment, there is the component of the defendant's behavior prior committing the crime, during the investigation, and trying to repair, and so on. So everything in your from what you do counts, and should count, at least under the law. But
I mean, we have a couple of cases like Dan Shova that attempted to delete data and destroy the hard drives, and also in the case of Collective with those fireworks administrator trying to delete the content of the hard drives with the contract.
okay, that's destroying the evidence, and well, at least I think this can be detailed better at
Okay. Okay.
lunch, because it can be a lengthy discussion.
Hi.
Hi.
Okay. So first, regarding the what you mentioned in the presentation regarding that you need to put in the contract every single tool or any license that not only methods. You said that
also the tools
the client,
you use,
the client, for example, let's say the client uses a Oracle database or or a server with a license from Microsoft that he doesn't own because it's a license. It's only have the right to use, he's not the owner of the software. So basically, you need to specify in a contract of pen testing every single element that will go in the scope of the contract. The problem, just a moment. Let me clarify the question. My question is, for example, if you are doing a black box testing, that means you're supposed to not knowing anything about his infrastructure. How you can mention that in the contract, because you are not supposed to know about what he has in his infrastructure. This is the first question. And the second is regarding the law of disclosure of private personal data and
data breaches.
Yes, but the Romanian authority that forced companies to register, and there is a there also you said that you must pen test on a testing environment. This is kind of completely unuseful because you don't test the real infrastructure, and
the costs for duplicating it are high. Yes,
it's kind
indeed.
of you are obliged to assess the security, but you are not allowed to assess the security.
Okay, the Data Protection Authority actually issues a lot of decisions that clarify situations. Maybe until right now, it's exactly like I said. The tester of a program should not access personal data in that program. Only anonymized data. This is the requirement. Okay, but maybe reaching to them and specifying the direction of security research, something like that. We can work and find some. Maybe they could issue some exceptions because the law forbids everything, and they issue decisions through which they establish a lot of exceptions. Yeah, and regarding the black box testing, sorry. Right now, without knowing at least if the system is really belonging to my client and I do not affect others, I personally don't advise testing. It's my Because I'm a lawyer. I find the difficulties and problems, and I warn about them. So
Okay, we
it's
have.
very
Sorry, we have one last question.
okay.
Hi, good talk first. So the question is, how do we make all these talks that
Sorry.
Yeah, can you hear me now? Okay. How can we make all these talks that keep going over and over again about the challenges that we have with the Romanian law regarding cybercrime, which is extremely vague and ambiguous? How can we actually start fixing this? You have close to 1,000 people around here who may or may not be willing to help. How can we make things happen? Because right now I've actually read cases where cyber criminals manage to remain free due to errors made by prosecutors, and at the same time you have all those researchers over here who may be willing to help the Romanian government secure infrastructures, but they feel they may be punished by the law just because they try to ping.
Okay,
Basically, this is the reality right now. If I ping a server from STS,
Yes.
I'm gonna be in trouble. Not more than that. If I want to.
Most certainly, you will have at least charges pressed for that. First of all, build up a collection of the problems, like in an organized fashion. Tailor it for the different. Identify the authorities where you should go. Judges, prosecutors are willing to be connected with what's happening in reality. But a single person going and saying something cannot count.
Right.
You have to gather and format the information for the particular audience. And regarding trying to pen test a server, well, this is like you said, it is a problem. This is why maybe we need some amendments, some provisions regarding the purpose of doing such research that should be taken into consideration when in an investigation. Also, keep in mind that unauthorized access or authorization means usually specific agreement from the owner, and second, it can come from the law. Touching a military installation, it's a different aspect. Coordinated vulnerability disclosure. Try to make institutions adopt that. They will create a mechanism so that you can reach out if you convince them of the utility of this. This is another way.
Okay. So what about? I know we're running out of time over here. What about doing a partnership between the lawyers, which you represent right now over here, and the researchers in order to make those proposals accurate enough to be taken into consideration by the lawmakers? Because
you mean giving a legal touch to what you gather as technicians?
Exactly.
I'm sure you can find lawyers to help out with that. Well, it depends on how knowledgeable of the technical stuff they are, but anyway.
Thanks.
I know a few that. Then the solution is to pay them.
We have.
Pay them to help. For money, I know. Thank you very much, everyone.